Hi, this is Professor Jeanette Mall on How to Think Like a Lawyer. Today we're going to start talking about the book, Why is the Law So Perverse? We're going to be looking at chapters 1 and also the introduction so that we can look at how the book is telling you how law is formed when we have multi-criterial decision making. The book itself is going to be what your final project is due on, so you're going to want to be reading it throughout the semester so that you're able to do that final project. Looking at the introduction, it starts with the statement that there are ideas that are preposterous on their face, and yet one is hard-pressed to say why. The book's about these ideas. So it starts with a proposal that we cut prison costs by 99%, and that is through the use of voluntary torture. States that prison is just one of many possible pain delivery systems, and unfortunately, it's one of the most expensive. So instead of making a prisoner's life moderately painful for a prolonged period of time, we would give them the option of an intensely painful or torture for a short period of time, so that we would have as much retribution and deterrence as before, but at a fraction of the cost. This would be entirely voluntary, and everyone will continue to have the option to serve his regular prison term, but whoever wants to can opt for this torture alternative. So it talks about then even though the amount of deterrence and retribution we get is virtually the same, the cost would be cheaper, so that it could be seen as a win-win situation, that we would not ever dream of adopting this because there's something perverse going on here. And so why? And so the book says it's seeking to explain why the law is full of perversities of this kind that are strange and counterintuitive features that one cannot justify, but that one would not want to eliminate either. The cause, it turns out to be, is logical in nature. So it then sets for other examples such as this that the book's going to be looking at. Things like the laws are replete with loopholes, ways that you're able to get around the law. The law also answers every question in an either-or fashion. It's black, it's white. It doesn't allow options in the middle between those two. And that there's also a lot of conduct that we intensely dislike. The example gives is ingratitude, and yet we refuse to make these illegal. These are all examples of things and problems that the book is going to be looking at, and it does it with analogy to the theory of voting. And voting rules have been found to be notorious for exhibiting innumerable logical paradoxes. So he then offers a glimpse into voting paradoxes on page 3 of the introduction, talking about Jean Deborah, who was preoccupied with rankings. So he was looking at elections by majority vote. And the example he gave is if you had 3 candidates and the voters prefer candidate A to candidate B, they prefer candidate B to C, and so then you would logically then conclude from that they would prefer A to C. But in fact, what Deborah found is that there's no transitive feature of voting. And so just because the voters prefer A to B and B to C does not, in fact, mean that they will prefer A to C. And in fact, this becomes even more convoluted when there is what is called an irrelevant option, an option that doesn't change the voters, that you have a candidate D, but you know based on his background that he is not qualified, but yet that will change the voting. It will change the outcome of the election. And he gives other examples of that, such as if there's fish and steak on the menu that you might, and chicken, that you might prefer one option, but then if the waiter tells you, well, the fish isn't really good today, that still might make you change your decision, even though you were never going to pick fish to begin with. He then goes on to talk about the voting paradox theory of Arrow. Arrow's theory is the impossibility theory. He came to the conclusion in answer to the question of, can one come up with a voting system that does not suffer from these flaws, where you're attempting to get the view of the majority, the vote of the majority, but it's not actually the outcome that results in the election. And he finds that that is impossible, that different voting systems can generate wildly different results. And then it's looked at further by Sen. He then looks at any voting system that tries to respect people's rights, is his conclusion, is bound to override their unanimous wishes on at least some occasions, that it's never going to correspond exactly with what that group of people actually wanted in every election. It's looked at further by Chalinsky. He says that he found that whatever method we use for voting, that sometimes something quite odd happens, and if only a few voters change their mind very slightly, it will completely turn the result of the election upside down. I know that I've looked at before that less than 1% of the population frequently impacts the outcome of an election. That sometimes people say my vote doesn't matter, but a very small percentage of voters can sway the entire outcome of an election. So the introduction then looks at page 6 on the fact that the law didn't originally look at this voting paradox theory for about 30 years. And that's because under statutory interpretation laws, what would happen is judges would look at legislation, and if there was something that needed to be clarified, something that was not clear in the law, they would try to interpret the piece of legislation by trying to get in the collective head of the legislature. And of course, the problem with that is there is no collective head of a legislator. And I'll tell you that's actually true. I've drafted a number of amendments in Ohio's adoption law. I draft them, I talk to representatives about them, and then they are voted into law. And even when they're unanimously passed, it's not a collective head decision. It's somebody is suggesting the idea, it's getting drafted, it's going through committees, it's going through a process, and then there's give and take in the legislative process as well on what's included in laws, what is not included in laws, what amendments are made. For instance, if there's a conference committee when there's a difference between the House and the Senate. But the example they use in the book about this is a 3-judge panel on a court of appeals. And the example they're talking about is whether there's duress and whether the contract is valid or not. And that you can have a 2-1 split on each of those issues, but it being different judges that are voting that way. And therefore ask the question, then what is the outcome of that decision? That it's creating this paradox. So again, the book is about multi-criterial decision making, which is something we do every day in our lives. If you want to buy a car, you're going to look at what is the price, what are the features you're looking for, and you're going to look at all of those, whether it's on a piece of paper or in your head, and you're going to be making that multi-criterial decision. And what sways you is going to be different than a different person. And so all of those factors are going to be changing your decision, making your decision for you, because we are looking at all of those things together. Legal decision-making is, in fact, a multi-criterial decision-making. You're looking at multiple facts, multiple laws. And so that's what you're looking at, bringing that all together and coming out with a final resolution. There's a couple more examples that are given in here in his introduction, but then he turns to page 9 of just outlining the book for you. The first part of the book is about why does the law spurn win-win transactions? Why sometimes when you say both parties are going to win in this situation, why is that still not the outcome that we're going to have into the law? So that's kind of going back to that first example that we talked about, and it's going to be explored further in the book. The second part of the book is the second part of the book is entitled "Why is law so full of loopholes? Why do we look for ways around the law? Why are there ways around the law?" So the second part's going to be looking at that. Third part of the book is why is the law so either or? Why is it black or white? Why are we not ever looking at a continuum of decision making within the law? And the fourth part of the book is why don't we punish all that we condemn? There's things that we think are inappropriate and yet we won't make them illegal. The example gives in the introduction is a bad Samaritan. When they sit on their hands and they don't help someone else, why is that not illegal? And so we're going to look at that at part 4 of the book. So the first part of the book, why does the law spurn win-win transactions, starts with chapter 1. And it again asks that question, why is it wrong to torture a prisoner when he consents to it to shorten his sentence? And the answer it gives you is consent does not always cure the wrong. And so then it's going to give you specific situations about that, but it does distinguish in the book that consent is worth respecting only when the consenting parties benefit and others aren't injured. And so that's a lot of times the reasoning why we don't do a win-win, because there may be third parties affected and there may be other factors that impact that. The examples he gives of other situations are first and foremost paternalism. if you've studied juvenile law is based on paternalism, the right of the society and the laws to ensure that children are safe in the role, paternalism, as a father. So paternalism is one reason why we don't allow consent. And the examples it uses in the book is such as using drugs or playing Russian roulette. The next thing it talks about is that consent shouldn't count. It shouldn't cure and it shouldn't bind if the consenting party is exploited. The example it's giving is shipwrecked people, that when the rescuer comes, they can't ask for all their fortune just because they can exploit that situation that those people want rescued, so that the law restricts exploitation. So that would be the next thing that he looks at. And then he talks about commodification. There are things our society says you can never buy or sell. Examples it gives is kidneys, cornea, sex, and babies, that they can be traded, they can be given away. There can be scenarios where that occurs, but we're not going to put dollar values on things such as our children. The idea is that consent should not impact in situations of paternalism, exploitation, commodification, that those are things that we can all agree should not occur. But then it asks why, on page 18, why is there no specific enforcement of promises in the law? And the example it gives is a kidney club where you sign up and say, well, I agree that I will give somebody my kidney if they need it, if in fact I get a kidney when I need it, but we're not going to enforce that promise. Our law won't allow that to happen. Our society says that that's not an acceptable response, that we're not going to hold you accountable to that promise. You might have to pay damages in that situation, but your promise is not going to be legally binding. Give some other examples of things that we're not going to allow, like tradable emission rights. In that case, it goes to that scenario that I gave you, that even if two companies agree that they're going to trade emission rights, there's still a community, a society, a neighborhood that's impacted by that. So there are third parties that have an interest in those tradable rights. And so we're not going to just look at the parties and whether they're consenting and whether it's their win-win. There's a couple other examples that are given there where your consent is just not allowed. Example, a man takes a job involving hazardous materials. We're not going to let him negotiate away his safety and safety equipment to make more money and then not hold the owner of that company responsible when the person is in fact injured in the manner that that hazmat required equipment was intended to prevent that harm. So those are things that we're not going to allow consent to happen on. So we're going to look further at this in the rest of the chapters having to do with part 1. So I look forward to talking to you next week. Thanks.